Good morning, Your Honors. The matter before the court this morning is the case entitled State of Vermont versus Alan Washburn, case number 23AP271. Representing the appellant, Alan Washburn, is attorney Brianna Hauser. Representing the appellee, State of Vermont, is attorney Evan Meenan.
Thank you very much, and good morning, counsel. We'll hear from counsel for the appellant first, of course. Please introduce yourself, identify your client, and then proceed.
Thank you, Your Honor, and thank you for permitting this argument to proceed remotely today. Brianna Hauser on behalf of appellant Alan Washburn. Mr. Washburn requests that this court reverse the criminal division's civil forfeiture order because the court lacked jurisdiction under 13 VSA 354, and alternatively because there was insufficient evidence supporting the court's order. I plan to focus my argument today on the jurisdictional issue in two parts. First, that 13 VSA 354D establishes a jurisdictional threshold requirement that an animal be seized under Section 354 before the criminal division has jurisdiction. Second, because Mr. Washburn's dog was not seized under 13 VSA 354, the criminal division lacked jurisdiction here. As an initial matter, the state fails to identify any exception applicable to this case to the general rule that subject matter jurisdiction can be raised at any time before a judgment becomes final. This is a direct...
May I inquire about the reason the dog was taken? As you point out, it's none of the reasons in 354. It was as a condition of release. And it was a court order as a result to do it. Was that a valid order?
So it's not clear. The state asserts that it was a lawful seizure based on a condition of release. It's not clear what law they're relying on there. The court is authorized to issue temporary conditions of release prior to arraignment under Vermont Rule of Criminal Procedure 5B. But as far as I understand, the conditions of release under 13 VSA 7554 don't include anything that would suggest that the court can require surrender of an animal, and 354B only permits lawful seizure if it's a voluntary surrender, if it's based on a warrant, or if it is based on exigent circumstances. And so we would argue that it's not a lawful seizure.
Okay, and that creates the odd situation that in a case where the court felt, and this is a court order again, that the issue of getting that dog to some care was critical. By making that order, under your argument, it meant that the state no longer could get a forfeiture order of the dog. So it would seem like that's a reverse as to the way the world should work. That is, when it's important to get the dog to someone, by doing it, you end up with the argument you're making is, therefore, you have foreclosed your right to ever get a forfeiture. Is that not what's happening here?
Well, I don't think it would foreclose the right to ever get a forfeiture. For one, if an individual is convicted of animal cruelty, the court can order forfeiture of an animal who was subject to abuse or any other animals. Otherwise, the legislature has made clear that lawful seizure of an animal by the state is only through the means under 354B. And so, that's a decision that the legislature has made. And I think that that's what this court has to look to in determining whether the criminal division had jurisdiction in this case.
But counsel, wouldn't you agree that if you're correct here, that would result in a reversal here, but there's still that the dog would not go back to its owner because of the existence of the condition of release, which you would have to then challenge in the criminal division. Is that right?
Yes, well, it's true that there is still an existing condition of release that prohibits Mr. Washburn from possessing animals, and that would still be in effect even if this court were to reverse the forfeiture order. I think it's possible that Mr. Washburn could seek a return of property and perhaps have custody by a family member or something like that, so that the animal it's actually returned to his ownership, but that he's not allowed to possess it under the condition of release.
Let me ask about a statutory construction question that you just argued, and that is that the exclusive methods of getting a forfeiture are to apply either B1, 2, or 3. They don't say that, do they? There's nothing that says these are the exclusive methods you must proceed in order to get a foreclosure, and foreclosure is covered in 353 as well as 354.
What 354D provides is that a civil forfeiture can be brought in the criminal division if an animal has been seized under 354. The state can then file a motion for civil forfeiture, and this is all a proceeding that can happen before there is a criminal conviction. So 353 is separate. That forfeiture happens when there's been a criminal conviction. This civil forfeiture proceeding is separate, and there's lower procedural protections for a defendant in these civil proceedings. But the scope of the criminal court's jurisdiction is provided for in 354D, which says that if an animal is seized under this section, the state may institute a civil forfeiture proceeding in the criminal division. There's no other provision of law that grants the criminal division jurisdiction over these civil proceedings for the forfeiture of an animal. And it's especially—
And that runs, that does it not, into the criticism here that you've made every statutory requirement a jurisdictional one, even though the statute doesn't say anything about this.
It's not that every statutory requirement is a jurisdictional requirement, but that here the criminal division's only authority to act in a civil proceeding for the forfeiture of an animal is under 354D. And it's particularly notable to look at 4 VSA Section 32, which explicitly gives the criminal division jurisdiction over certain other civil proceedings. So the criminal division doesn't generally have jurisdiction over civil proceedings, but the legislature
there's no procedure for a civil proceeding in the civil division, is there?
So the civil division has general jurisdiction over civil proceedings. There isn't a statutory provision that explicitly addresses a civil forfeiture proceeding in the civil division. But the fact that the criminal division is not explicitly granted authority under any other provision over these proceedings, except in the case where the state has filed the motion after the animal has been seized under 354. And so that has to be, because that's the court's only authority, and that authority is by the plain language of the statute limited to circumstances where the state has seized the animal under 354, that the only way to read that is that it is a jurisdictional limitation, and that the court's authority is limited to those cases.
But Ms. Hauser, isn't your argument really that the state used the incorrect method of seizure here by not getting a warrant? And even if they did use that incorrect method, doesn't this court still have jurisdiction over the state's motion?
It is our argument that the state was not authorized under 354B to seize the animal in this manner. And because the legislature has made lawful seizure under 354 a jurisdictional threshold requirement for the criminal division to address a civil forfeiture motion for an animal, that's central to the jurisdiction of the criminal division and this court's jurisdictional analysis. In this case, because Mr. Washburn's dog was not seized under 354, the criminal division lacked jurisdiction over the civil proceeding. The state has conceded that this was not a voluntary surrender, nor was the animal seized pursuant to a warrant. 354B permits warrantless seizure of an animal under exigent circumstances, but it's the state's burden to establish that, and they have not done so here. They try to argue that the passage of time between when Officer Morawski first showed up in the parking lot and when the animal was ultimately seized shouldn't matter, but that's central to this court's analysis of whether the animal was seized under exigent circumstances. The fact is that Officer Morawski waited for an entire process to play out of Mr. Washburn to be arrested and then for these conditions of release to be issued by the court. And so there is no argument that getting a warrant was impracticable or impossible in that time. Unless there are any further questions, I would reserve the remainder of my time for rebuttal.
Okay, thank you very much. I don't see any hands, so we'll turn to the counsel for the appellee. Please identify yourself and your client and then proceed.
Good morning, and may it please the court. My name is Evan Meenan, and I represent the state of Vermont. The court's questions so far about the jurisdictional issue that's been raised and the intersection with the pending criminal charges made me go back and read the language of Section 354D again just now. And it's very interesting because it spells out the possible ramifications of this court's decision if it were to adopt appellant's rationale. So subsection D reads, if an animal is seized under this section, the state may institute a civil proceeding for forfeiture of the animal, blah, blah, blah. And then the second sentence is the interesting part. It says, the proceeding shall be instituted by a motion for forfeiture if a criminal charge has been filed, or a petition for forfeiture if no criminal charge has been filed. The reason why that second sentence is very interesting is because it makes it unclear whether or not the first sentence also modifies that second one. In other words, if the second sentence is read in conjunction with the first, appellant could theoretically argue in the criminal case that the state is precluded from seeking forfeiture even if the state obtains a conviction, because, as appellant's arguing in this appeal, the animal was not seized pursuant to Section 354. And so,
post-conviction, don't you have the remedy under 353?
well, that's very interesting because if the court's questions were talking about what would happen if there was a reversal here, and would Chad have to be returned? Section 354G2 states, no, Chad would not have to be returned if a criminal charge is pending. However, the language of Section 354 subsection D that I just read calls that into question if appellant's argument is adopted. And in the state's position, that's another reason not to adopt the defendant's position, because it would mean that the state could not, at least temporarily, hold on to an animal, even though there's reason to believe that it has been treated cruelly, if it obtains lawful possession of that animal through any other mechanism aside from Section 354B. Now, in this particular case, it's the state's argument, one, that Section 354 does not set any jurisdictional thresholds, and two, even if it does, the state did seize Chad pursuant to Section 354. Getting to the jurisdictional issue first, it's the state's position that claim is not preserved. And even though this court has recognized that jurisdiction may be raised at any time, there's good reason not to address that argument in this appeal. And the reason for that is, as this court recognized in the Tibbetts case, it will not review jurisdiction even under plain error when the failure to raise a jurisdictional claim deprived the trial court and the state of the opportunity to develop a sufficient record in order to review that argument. Had appellant challenged the state's jurisdiction or the court's jurisdiction below, the state would have been able to do at least one of two things. First, they could have obtained a search warrant even after the conditions of release were imposed, and then refiled its civil forfeiture motion. Or in addition, it could have developed the record with additional facts to support its contention that there were exigent circumstances that justified seizing Chad. The state had no incentive to develop that record in this case because it had no reason to know that appellant was challenging Chad's seizure, just Chad's forfeiture. If this court does address the jurisdictional issue, it should conclude that appellant's challenge really isn't a jurisdictional one. Subject matter jurisdiction pertains to a court's ability to determine a general class or category of cases, and Section 354 makes it pretty clear that it's the criminal division that has jurisdiction over animal forfeiture proceedings. And this
if we find that this is outside of the seizure is outside of 354, isn't that a class of cases?
No, it's not. The class of cases is the forfeiture itself. Just because, and the authorities, both from this court and others that are cited in the state's brief, make it clear that just because a court erroneously asserts jurisdiction over a specific case that falls within the general class of case, that doesn't make any resulting judgment invalid and subject to reversal. And that's especially true when a party doesn't object. For example, in the Thompson case, this court said, even if we found that the court improperly exercised its jurisdiction, that erroneous exercise of jurisdiction is not the type of fundamental jurisdictional defect that would compel this court, absent a timely objection on jurisdictional grounds, to vacate any order. And this court reached a similar conclusion in the BC case, which was a Chins case. And this court said, when a court has jurisdiction over a general category of case, the fact that the court errs in exercising its jurisdiction in a particular case within that general category is not sufficient to make the resulting judgment void for lack of subject matter jurisdiction. I think,
but isn't the my point is, isn't the general category of cases those that are set forth in 354B?
No.
Why?
Respectfully, no. The general category of case is animal forfeiture case, right? And this is why, as the state points out in its brief, there's a difference between jurisdiction and the authority to act, right? So the general category of case is animal forfeiture cases, and that's what the court had jurisdiction over. Section 354B arguably at most sets forth the circumstances in which the state has the authority to act, and the act is seizing an animal. Just because the state did not have, arguably, and the state's not conceding this, didn't have authority to seize Chad pursuant to 354, it doesn't mean that the court lacked jurisdiction over the subject matter of the case, which was whether or not Chad should be forfeited. And one really easy way, I think, to analogize this is to specifically consider what would happen under Section 354B2, which pertains to seizures that are conducted pursuant to a warrant. Now, let's say the state went ahead and got a warrant, right? And then it had a warrant and it seized an animal. And then the animal's owner comes forward and says, wait a minute, that search warrant was improvidently granted. There was no probable cause here. That argument wouldn't mean that the court lacked jurisdiction over the case. It would just mean that the court had to consider whether or not the search warrant was adequately supported. And if the search warrant wasn't adequately supported, then you would suppress evidence or order the return of an animal. Again, it goes to the distinction between the authority to act and jurisdiction. Now, it's the state's position that it did come into lawful possession of Chad pursuant to 354. Exigent circumstances is the situation that I will address first. And really the important fact to consider is that there's a fundamental disagreement, I think, between the state and appellant as to when Chad was seized. Appellant wants this court to conclude that Chad was seized at the police station after the court imposed temporary conditions of release. The state disagrees. It's the state's contention that Chad was seized when appellant was seized, i.e. when appellant was arrested. And appellant was arrested and placed into custody in that Walmart parking lot when he was told to follow Officer Morawski back to the police station. Chad was effectively seized at that same time, and it doesn't matter that Chad was left in appellant's car rather than transported in some other means. There were some really good reasons to do that. First and foremost,
Mr. Meehan, I'm sorry for interrupting you. So then your point then is because a court found probable cause for the arrest, then the siege and conditions set where the appellant could not have possession of any animals, then that is proper. We don't even have to consider the 354 issue.
Well, there's the state's really making two different arguments with respect to Section 354. Well, three. One is it doesn't set jurisdiction. And so even if this court were to conclude that Chad was not seized pursuant to 354B, the resulting forfeiture judgment would not be subject to reversal because 354 does not set any jurisdictional requirements, and appellant never made this argument below. With regard to how Chad was seized, the state is making two 354B arguments. The first of which is Chad was seized in the Walmart parking lot pursuant to exigent circumstances because he was showing signs of heat exhaustion after being kept in an inappropriately small car, a coupe, without any water, without any air conditioning, and with the windows barely cracked. That's the first argument. The second argument relates to 354B2, which is seizures pursuant to a warrant. Now, the state is basically making a harmless error argument that's kind of akin to the inevitable discovery doctrine that applies to unlawful searches and seizures. Under the harmless error standard, one of the things this court has to conclude is that the appellant's substantive rights were affected. And what we're saying is, what the state is saying is, no substantive rights were negatively impacted because the conditions of release, not even the temporary ones, but the state's forfeiture motion was filed after permanent conditions of release were imposed. And those permanent conditions of release were imposed after the court concluded there was probable cause to believe the appellant was cruel to Chad, the same exact determination that would have been made during the search warrant process, but also the appellant was present and had the opportunity to challenge that probable cause determination in open court, as opposed to, for example, during an ex parte search warrant application process. So we're not really arguing that this is, that you never have to get a search warrant if this plays out. What we're arguing really is there's harmless error because no substantive rights were impacted. And so now, if this court disagrees and concludes that the state's argument regarding subsection B2 is meritless, and that the evidence as it currently exists does not support an exigent circumstance argument, then the appropriate remedy in the state's mind is to remand this case for the court to take additional evidence regarding exigency and then make a determination after doing so.
Let me ask a question related to that, which is nothing is said in the briefs about the criminal proceeding. Is that still pending? And is there ever been any expectation it would go forward?
I can provide an update on that, Your Honor, because I actually just looked this up in anticipation of that question. And as the state outlined in its brief, for a very long time, that criminal prosecution was being stalled because the defendant had refused to participate in a competency evaluation. Now, it turns out that on June 5th of this year, a competency evaluation was submitted to the criminal division, and it found that the appellant was incompetent. Now, there could be some litigation around that if the state disagrees and thinks that the appellant is competent. But even assuming that he is incompetent, that creates a really sticky situation, because if this civil forfeiture is reversed, then pursuant to 354, I think it's D, the state will immediately file a motion for forfeiture in the criminal proceeding, as opposed to pursuing its petition for forfeiture in a civil proceeding. And it will argue that as a result of subsection G2B, Chad cannot be returned to appellant because the criminal proceeding is pending and will be pending indefinitely until he is deemed competent. And Chad will effectively be with his new adopted family simply because this case is, the criminal case is still pending, which is really highlights another reason why appellant's argument should be rejected as an irrational reading.
You have 1 minute, counsel.
Thank you very much. Then I'll end with this, that if this court were to adopt appellant's reading of 354, which the state asserts would lead to irrational results, it would create an incentive for the state to file criminal charges in any other proceeding where it comes into lawful possession of an animal, aside from the 3 situations identified in 354B. And for policy reasons, I don't think that we want to encourage that when an adequate result can be obtained through civil forfeiture and the avoidance of a criminal conviction. Thank you very much.
Okay, thank you very much. How much time does the appellant have, please?
Appellant has 3 minutes and 54 seconds remaining.
Say that again, please.
Appellant has 3 minutes and 54 seconds remaining.
Thank you very much, counsel.
Thank you, Your Honor. A few points I'd like to make. In response to the state's arguments that cases like Thompson and In Re BC, In Re CLS apply in this case, those cases all involved collateral challenges to final orders. There's a specific requirement that jurisdiction can only be attacked if the entire category of cases is outside of the jurisdiction of the court. That's not the case here. This is a direct appeal of an order. It's not a collateral attack of a final order. But even still, as Justice Eaton has pointed out, the legislature has provided that the category of cases that the criminal division is authorized to act in is cases where the state has brought a motion for civil forfeiture after seizing the animal under 354. The legislature acts with extreme caution when it creates civil forfeiture statutes because it is a significant procedure and it has a significant impact on an individual's due process rights. And in this case, the legislature has provided that an animal can only be lawfully seized under 354B, and that is a jurisdictional threshold requirement for the court to order permanent forfeiture of an animal in a civil proceeding prior to a conviction. It's not a high bar to require the state to lawfully seize an animal before seeking permanent forfeiture of that animal from an individual absent a criminal conviction.
That brings us back to the question about the order that got issued here. Do we have to rule in order to go your way in this case that the condition of release was invalid, that the court could not issue that condition?
I think that under 354B that the state can't seize an animal pursuant to a condition of release and then have the criminal division have jurisdiction to authorize civil forfeiture. I think that.
And that means, do I understand right, that you've always put it in the way the criminal division can't do it. The fact is no one can do it, right? It's either 354B, a motion in a criminal proceeding, or it's nothing.
what 354B provides is for the criminal division's jurisdiction over these proceedings. While the civil division has general jurisdiction over civil proceedings, there's no specific statute that authorizes the civil division or that addresses the civil division's jurisdiction in these.
You have 1 minute, counsel.
Again, I would what appellant's reading of this statute does not affect the court's authority under 353 to order forfeiture of an animal after conviction. Again, this is not a high bar to ask the state to get a warrant or to otherwise lawfully seize the animal under 354 before the court can order permanent forfeiture of an animal. For those reasons, we would request that this court reverse the forfeiture order.
Okay, thank you very much. Please now call a conclusion.